I am so thrilled to be here at the beginning of something that I think is going to be very significant, not only for NPRI, but for the entire state of Nevada. Ronald Reagan once said, if you can't make them see the light, make them feel the heat. And NPRI has been helping people see the light for an awful long time, but many times that's simply not enough. And if you have a way to bring the heat as well, that is going to tremendously amplify the effectiveness of this organization and will bring a new weapon in the battle for freedom here to Nevada. I like to say that I have the best lawyer job in the entire country. I get to choose my clients, I get to choose my cases, I don't have to charge my clients anything to represent them, but best of all, the people I get to sue are bureaucrats. It's so much fun, it really is. And now that's going to happen for Joe Becker as well. I thought that I would talk to you today about three cases in particular that I think will illustrate the realm of the possible for the new litigation center. But before I do that, most people will think of this as a litigation center, but it will add to the potency of the organization in other ways as well. If you publish a policy recommendation and bring it to a state legislator or a county commissioner, oftentimes they'll be polite with you, but they'll put the paper aside. But if there is that implicit promise that, well, heck, there might be litigation to follow, it makes the policy recommendations all that much more significant. As far as the litigation center benefits in turn from the high quality policy research that the policy experts do. When we litigate a case in the area of economics, for example, I know very little about economics. But when I can turn in-house without having to pay $250 an hour for an expert to our very own Goldwater policy analyst in economics or education or whatever, it's a tremendous benefit. And one thing that the liberals have been tremendously effective at for for decades is something that we have come to call litigation by letterhead. And sometimes all it takes to get a government official to do the right thing or to stop doing the wrong thing is to write a letter. And if that letter is signed by an attorney, it just has a whole different dynamic to it. And we have found that we've had as many victories by letterhead as we have in the courtroom, and boy, does that deliver bang for the buck. But three cases I'd like to talk to you about today. One of them was a case that I litigated when I was with the Institute for Justice, which is a national law firm that litigates around the country. In fact, a few years ago, IJ challenged the limousine monopoly here in Las Vegas. Some of you may remember that lawsuit. But 3.5 years ago, as Steve indicated, I moved to the Goldwater Institute to start the first state-based litigation organization that would focus on state issues and the state constitution. And the success has been tremendous so far. In 3.5 years, we've grown from 2 lawyers to 4 lawyers. We had a wonderful, wonderful start to this week because on Monday, the United States Supreme Court agreed to hear one of our cases, which is, as most of you probably know, a very, very unusual circumstance. And at IJ, it took us a dozen years to get our first Supreme Court case, which was the voucher case that Steve mentioned, and to be able to do it in only 3.5 years at Goldwater, we're just as tickled as can be. And we have found that for people who've supported the Goldwater Institute in the past, they're even more supportive of the Institute now because we follow up our policy recommendations with action. And we represent the little guy against the government bureaucracy, and that gets people really excited. In fact, there are supporters of Goldwater who were not previously. But the case that really made me realize the potential for state-based litigation was a case that I litigated earlier in this decade when I was still with the Institute for Justice. Now, many of you, if not all of you, are probably familiar with the infamous U.S. Supreme Court decision in Kelo versus City of New London. That was the eminent domain case, which the Institute for Justice also litigated in federal court up to the United States Supreme Court and unfortunately lost. But that was the case where the City of New London, in its wisdom, said, we are going to bulldoze an entire working class neighborhood to make way for amenities for a Pfizer plant that we need very desperately to retain here in New London. And the homeowners fought back, and it went all the way up to the United States Supreme Court. And the Fifth Amendment says that private property shall not be taken for public use except with just compensation. And so it appeared to most people that you would have to take property for a public use, for a park, for a street, a hospital, a school, that sort of thing. But for amenities for a private corporation, that should not be within the government's power of eminent domain, which is one of the most sweeping powers and destructive powers that government has. Well, the U.S. Supreme Court saw it differently, and they looked at the words public use, and they saw something different than what we saw. They saw the words public benefit. If it is for a public benefit, then it's okay for government to use eminent domain. And who defines what a public benefit is? Well, of course, our government officials. In this case, an unelected commission. Many unelected commissions today exercise the power of eminent domain, so there's not even a democratic response that you can have to it. But the United States Supreme Court, by a 5-4 decision, upheld that taking of property. And at the very same time as we were litigating the Kelo case unsuccessfully in the U.S. Supreme Court, we were also litigating a case in Arizona on behalf of a man named Randy Bailey. Randy Bailey is one of those Americans who works very, very hard and asks the one thing from his government that government seems totally unwilling to do, to be left alone. He had owned, family-owned, actually he was the second-generation owner of a brake shop at the corner of Country Club in Maine, which is in Mesa, a suburb of Phoenix. And, you know, he's just working hard, employing people, paying taxes. But it turns out this is a very desirable intersection. It's the most heavily trafficked intersection in the city of Mesa. And a local hardware store owner wanted to expand his hardware store and thought this would be a nifty place to do it. And instead of going to Randy and to the other business owners and the homeowners who lived at this intersection, he went to the city council and he said, I would like that property and I would like you to use your power of eminent domain to take it and give it to me. And the city council, looking at that, said, you know what, we will do that, but under one circumstance, under one condition. You also have to accept a $2 million subsidy. They know how to drive a hard bargain in Mesa. So, of course, he said yes, and immediately eminent domain proceedings occurred, and the property was subject to seizure. Well, the Arizona Constitution has an eminent domain provision in it as well. And what you'll find is in all 50 state constitutions, there are provisions that do not exist in the United States Constitution that go beyond the restraint on the power of government that exists in that Constitution,